For another cause, and I'll let him do it. Tim Grendell.
Thank you, Pastor. Thank you. It's kind of fortuitous for standing out there in the park tonight. For Mr. Carson, Mr. Week, pay close attention because I'm giving you the truth back, and maybe you and your political opportunists can stop lying, misleading the people of this county, and committing fraud on the good citizens of this county, and deal with the truth. Because that's what I'm here to talk about tonight. I'm not here to tell you my side of the story, which is the announcement said. There is no side of a story. I'm here to tell you the truth. First truth. Somebody went to great lengths not to get me here this evening. Somebody sent me this email this past Monday morning. It's an email that says, Tea Party meeting has been canceled on September 18th. Interestingly enough, this email comes from Kevin Eshelman, who's Pastor Sanders' right-hand computer guy. I said, well, nobody told me about canceling the meeting, so I called Pastor Sanders. And I said, why'd you cancel the meeting? He said, we didn't cancel the meeting. I said, well, I got this email from Kevin. He says, Kevin's standing right here. I talked to Kevin, and Kevin told me he didn't send out this email. So somebody's devious enough to hack into somebody's email to try to cancel this meeting and keep me from being here tonight because they don't want you to know the truth. Now, I'm going to talk about truth, and we need to have, you're all conservatives, and maybe not all of you, some of you apparently aren't, but there's an absolute truth and there's moral relativism. For example, the world is round, and the sun rises in the east and shortly will set on us in the west. People on the liberal side of the element will tell you they're entitled to their belief. The world is flat and the sun rises in the west. And when you say, no, sun rises in the east, they say, I have my right to my belief, and the sun rises in the west, and therefore we're both right. And the sun, I have as much right to say the sun rises in the west as you do in the east. And you know, under the First Amendment, they do. And as probate judge, I will tell you what I call people who tell me the sun rises in the west. Delusional. Because you see, there are absolute facts. There are truths. The sun rises in the east, the world is round, the sky is up, and the ground is down, and no matter how much political opportunists want to tell you otherwise, there is absolute fact. And that fact is balanced against delusions, misrepresentations, and lies. And when it comes to the letters that have been going to the paper about the Park District and me, they are chock full of delusions, misrepresentations, and flat-out lies. Let's start with one. Linda O'Brien. You all know Linda O'Brien. She got a contract from the Park District. Not from me. She got a contract from the Park District interim director, Mr. Oros. He had the absolute legal authority to give that contract. Absolute. You can look it up, 1545 in the bylaws of the Park District. Absolute fact. Delusion. That somehow that contract was improperly given to her. It was a no-bid contract, and that since it was a no-bid contract, it was somehow unlawful, immoral, or improper. Well, I'm going to stick to the law tonight. I'm going to stay off opinion, and I'm going to back up every one of my facts as I require in my courtroom with statute and evidence to offset the delusions, the misrepresentation, and the lies that are put in the paper under the First Amendment. They have a right to lie, and they're doing a darn good job. They have a right to mislead, and they're doing a darn good job. But let's talk about something. 1545.07 of the Revised Code. And when I do numbers tonight, it's all reference to the Revised Code unless I tell you otherwise. 1545.07 of the Revised Code says that a Park District can contract for services at any amount without bid. There's no bid requirement under the Revised Code for a Park District to hire services. If they buy goods under 1545.07, they have to take a bid if the goods are over $50,000. Linda O'Brien's contract for $16,000 from the Park District, not Judge Grendell, was for services. And 1545.07 does not require a bid contract for services. In fact, in theory, a Park District could take $1 million contract for services and not require a bid. And that is Ohio law. You don't like the law? People go down to Columbus and change it. Good luck, but that's what they have to do. That contract was proper. The contract was inside the statute. The contract was done by the director with his authority. And to say otherwise, to imply otherwise, to try to make it sound like something improper was done there is simply committing a fraud on the residents
of Jogga County and in violation of both ethics, morality, and frankly, a total ignorance of the law.
Amen.
Now, let's keep talking about the law. I took an oath. It was a simple oath when I became judge. Uphold the Constitution of the United States and the state of Ohio and the laws of the state of Ohio. Amen. And that is all I have done on the bench and with respect to the Park District. The first code section we're going to talk about, section 1545.11. This deals with donations to the Park District. And it states, and this is a quote from the statute, each donation shall first be approved by the probate court before acceptance by the board. Each donation approved by the probate court before acceptance by the board. Now, before those environmentalists and all those folks who want to politically say that Grendells passed this statute when they were in the legislature, because that's going to be the next set of letters, that we passed the statute saying that we passed the statute. I just want you to know it was effective in 1972. I was in my second year of college when the statute was passed. I wasn't anywhere near Columbus, and neither was my wife. But this statute says each donation shall be approved. My predecessor, and the key words here is each, because my predecessor in 1994 signed a judgment entry that said the court approves any and all donations and gifts to the Park District. That's not what the statute said. It says that the judge must approve each donation. Not a blanket approval in the future, but each donation means when it comes in, you have to approve it. Why? To prevent corruption, to make sure that there's no improper donations to the Park District or board to somehow take an advantage of the park process. That's what the law requires. When I found that order, I vacated that order and followed the law that I took an oath to. And I've approved each donation that has been presented to me for the park. Mr. Patterson, in a letter to the editor, makes it sound like I'm a control freak and lost my mind and I have to control everything in the Park District. I do 17 to 20 cases a day, folks. I got way too much on my plate to worry about every day what's going on at the Park District. But the last director wanted to be cute. He would send me emails saying there's a $1.21 donation in the box here at Westwoods. We need you to approve it. Here's a $3.72 donation. And then buried at the bottom, here's a $750,000 donation from the foundation to the Park District. And I approved in each and every one. Mr. Patterson made it sound like somehow I was keeping kids from getting binoculars because I was approving the donation to the park board. I was approving it because the law requires me, the probate judge, to approve each donation made to the park board before the board can accept the donation. Not my law, folks. The law, though, that I took an oath to uphold. Now, what happens when you don't take the donation? Well, you got to hear about the Falcon estate. Falcons were couples that lived here in Jogga County. And they gave what was called they gave a deed to the Park District of some land, 25 acres in Munson. And they reserved what's called a life estate. They lived on a house on the property. And under their deed, it said when the second one dies, the Park District has to remove the house within 30 days, or the land will revert to a Virginia land trust. So, Mr. Falcon dies. Mrs. Falcon, unfortunately, commits suicide. When she commits suicide, the Park District takes over the contents of the house. The contents of the house were never transferred to the Park District. That's called personal property. You have real property, your house and your dirt. You have personal property, your car, your guns, your jewelry, your furniture, your knickknacks, and your heirlooms. Well, the Park District, for reasons that defy logic, took over the Falcon estate, sold the personal property, buried the car on the Park District property. Right. Now, you've been reading the letters to the editor from the environmental folks who are concerned that we're letting children play in our parks, that's somehow harmful to our parks. Yet, when a car is buried on park property, nobody seems to be upset about that from an environmental perspective. Where were their letters? Where was their complaints about the park board, a lack of trust, when the park board and its prior director were burying a car that they didn't own, by the way. They were burying the car owned by the Falcon estate on park property. Where were they when they sold the Falcon personal property from that house? And let's talk about the 9 guns. 9 guns that Mr. Falcon owned mysteriously disappeared. Those guns eventually were found, including a 1929 Thompson submachine gun, which is subject to federal gun law regulation. When I first asked the question, and let me tell you how I know about the Falcon Estate. The prior board was so in sync with the prior director that employees of the Park District were afraid to say anything out of fear of retribution. But when I put Mike Petrozzulli on the board, suddenly they realized that they had a director who was willing to stand up on his own and do what was right. And somebody from the Park District came to Mr. Petrozzulli and told him about the buried car on the Falcon property and told him about the guns that were missing from the Falcon Estate. And that started the process of looking into this. And indeed, the car was buried. Since then, the Park District has dug it up. I called the past director in and said, what can you tell me about the Falcon Estate? And why am I involved in this? Not because I'm a control freak. I am the probate judge. I am legally required to make sure if there was assets of the Falcon Estate that were going to go to an heir of the Falcons, that they go to the Falcons and not get sold off with money going to the Park District. Because that's the oath I took when I became your probate judge. Now, what do we find out? I call in the past director and say, what do you know about this? Oh, Judge, we looked all over for heirs for the Falcons, and when we couldn't find them, we talked to our lawyer, and our lawyer said, just sell everything off, and if somebody ever shows up, you can give them money. A, that's not what the law says, but that's what he claims he was told. B, we couldn't find the title for the car. And so when we didn't find title for the car, we just buried it on the property. Wow, that was genius. We just buried it. And where are the guns? Now, here are the answers I got. What guns? There were some guns. The guns are being held by some former park rangers for safekeeping. We don't have any guns. The guns are with the sheriff. I got so many answers on the guns, I didn't know what to do about the guns. What we ended up doing was forcing the Park District, frankly, to open up two estates, one for Mr. Falcon and one for Mrs. Falcon. And, remember the Park District couldn't find the Falcon heirs? Well, Mrs. Falcon's sister lives in Sagamore Hills. Not very far from here, folks. We're not talking about Poland or Eastern Europe. We're talking Sagamore Hills. And Mrs. Falcon was contacted by the Geauga County Sheriff's Office on the night that her sister died to identify her. Was brought to Geauga County by the Sheriff's Office to identify and to go to the house to identify and to secure that things weren't taken from the house. So how is it that the Geauga County Sheriff knew about Mrs. Falcon's sister, but the Park District didn't know about Mrs. Falcon's sister living in Sagamore Hills? The estates are now open. The situation is being corrected. The car has been dug up and is properly disposed of. The Falcons will get properly compensated for the assets that were improperly sold out from underneath them. And then we have those pesky little guns. 2 weeks ago, the lawyer for the estate, good young man from Burton, hired a guy from Canfield, who's a lawyer and gun appraiser, who's actually a former 82nd Airborne soldier. And he's in my courtroom giving me the valuation on the guns. And then he says to me, Judge, I think 2 federal firearm laws were violated in the handling of these guns. And so that matter is going to be sent down to the U.S. Attorney's Office to investigate. Where were the letters and the cries and the human outcry about lack of trust in our park board when this kind of stuff was going on? And there was a report done at the behest of the board from last year. And in that report, it was an investigation by an independent attorney. He confirmed and concluded that one of the reasons this happened is that the donations to the Park District were not being approved on an ongoing basis by the probate court. Because had they been approved, the judge would have been told, hey, we got these assets sitting out here. A house full of property, which was sold for $500 to the guy who caved in the house. A car, which is buried. And some guns somewhere, somehow, someplace. So that's why there's a statute that says I have to approve these donations. Not because I've got a control problem, but because there's a law that requires accountability. Next on the list, 154507. I didn't write this. This is 1996. Full disclosure, my wife may have voted for this for all I know. She doesn't remember. But it says that park board members are appointed by the probate judge. Back in 1996, I had no idea I was going to be the probate judge. I didn't have any idea I was going to be the probate judge in 2006. But I get to appoint these 3 people, folks. And the statute does not provide for an executive director. If you read 154507, it says there's a park board responsible for the operation of the parks, and they can hire 2 people that are actually named in the statute. A secretary and the treasurer. It also says in that provision that says they can hire other people for services without any bid contract requirement in the statute, they can hire anybody else they want. And what the park districts have done over the years is created the position of the executive director because the park board members don't get paid. They're not going to work 8 hours a day or 6 hours a day or 10 hours a day. So they created the position of the executive director. But that director works for the board doesn't work for the director. But for those who like to get public records requests, I tell you, go get some records from the park board for maybe 5 or 6 years ago. And you will read the minutes, and it's very interesting. You will conclude that there is more direction coming from the director to the board than from the board to the director. And in fact, time after time, the director would tell them what's up, what has to be done, and then ask for a vote. And then a vote would be taken. The statute is an inverse under that scenario. The board tells the director what to do. The director doesn't tell the board what to do. And in fact, for years, there were no votes on the Geauga County Park Board. And I'm not saying no votes turning something down. I'm saying no 2-to-1 votes. There were no votes because we had an inverse leadership model going on with our park board. We had issues when I came on the park board about conflicts of interest. I had 2 of my park board members at the time who had become millionaires by virtue of the Geauga County Park District. The Geauga County Park District bought real estate from one of those people for over $1.4 million and from another and his family for over $3 million. After they were made millionaires by the Park District, they were subsequently appointed to the Park Board. So there was no conflict in the purchase. I don't want to mislead anybody. The purchases were pre-board membership. But I have a problem with just, if you make me a millionaire and then put me on your park board, do you really think I'm going to give you a lot of resistance when things are coming before me? You can answer that question for yourself, but I thought there's something not quite right. We had in our park district, until Mike Petrozzullo discovered this last December, we had a direct web link from the Geauga County Park District when you went to one of our parks to the private commercial website of one of our park board members. I don't believe that's proper. And we had another member of the park board that I inherited, who was also the president of the Western Reserve Land Conservancy Park Board. And while he was on the board of the Geauga County Park, the Western Reserve Land Conservancy was receiving fees from the Geauga County Park District for providing assistance in acquiring land, such as Orchard Hills and land in Middlefield. My problem with that is, first of all, I don't know why a nonprofit like the Western Reserve Land Conservancy, whose sole purpose of existence is the preservation of land, would be paid a fee for doing their nonprofit purpose. It's like the Red Cross coming in for disaster relief and being paid for providing you the disaster relief. So I don't think that quite adds up correctly. But more than that, there was just this appearance of too much incestual relationships between the organizations. So what happens? I get to appoint. Now, the appointment statute actually dates initially back to 1953. So for those of you who are going to write letters to the editor saying that Grendell's passed the statute so that Judge Grendell can appoint people to the board, I was in diapers in 1953. That was the year I was born. I didn't have anything to do with that statute either. But it's interesting. There's another part of the statute. 154506. The probate judge may remove, and this is a quote, board members at the discretion of the probate judge. Written again and passed in 1953, long before I got to the legislature, for all those who are going to write these ugly letters. But discretion means freedom to decide what should be done based on the judge's judgment. I have, based on the Ohio legislature, 154506, the ability to remove every member of that board at my discretion. All I got to do is give them 10 days notice in the public hearing. No cause, no purpose. I can remove them all at my discretion. I didn't pass the statute, folks, but it's the one I took an oath to uphold. So do I have ultimate responsibility for the people on that board? You betcha. I appoint them, and I have the power to remove them if I think they're doing something that's not in the best interest of the parks in my discretion. There are some people who write those ugly letters who aren't happy with this. And they're going to go down to the legislature and try to change the law, knock themselves out. There's 88 other probate judges. There's an awful lot of folks who served in the legislature who aren't going to be real easy to move on that. But it's discretion. Now, and what I did last year, so you know, is I did remove the board and replace the board with new people because there was so much dissension going on last December that I just decided we needed to start fresh at the board. Mike had to leave because he became a township trustee. There was threats between the other two board members, and I was invited to a luncheon on a Saturday in December where the gentlemen all threatened me. They told me they were going to get lawyers, and they were going to sue, and their lawyers were going to sue their lawyers, and these lawyers were going to sue these lawyers. And I said, I had enough of this. And so I just removed the board and started all over again, as I'm permitted to do under Revised Code 154506. Let's talk about the tax collection issue, or the suspension thereof. Nobody took away the rights of any voters, okay? Because you see, the right to raise taxes is in Chapter 5705 of the Revised Code, called the Tax Levy Law. And 5705 has a checks and balance provision in that very code section. And that's in there because of Chapter 12, Article 12, Section 5 of the Ohio Constitution. And what the Ohio Constitution and Chapter 5705 state is that governmental bodies can't collect more taxes than they need for operations. That's in the law, folks. I didn't invent this. And by the way, that law, just so we state, that law predates me by about, 30 years. At least my time in the legislature. The Constitution and the statute says you cannot do that. You cannot hoard money. And in fact, Chapter 5705.341 says you may levy taxes for the object of the tax. 5705.341, and you can read it for yourself. This is a direct quote from the statute. No tax rate shall be levied above that necessary to produce the revenue needed by the taxing district or political subdivision for the next year, the ensuing year. Cannot levy any tax. It's in the statute, folks, even if approved by electors. So the statute says you cannot collect excess tax beyond need, even if it's voted on by the electors, unless such rate of taxation for the ensuing fiscal year is clearly required by a budget of the taxing district. So how does this work? And by the way, the Budget Commission under 570527 was created for this very check and balance purpose. What the Budget Commission's job is to make sure is that taxing entities do not collect taxes beyond that which is clearly required by their budget for the next year. Now let me tell you the game that goes on. Bodies come before the Budget Commission with excess money in their pockets. And on paper, they invent places to put their money. So they get past the Budget Commission. It's the Budget Commission shuffle. I got extra cash. I don't want you to know about my extra cash, so we're going to spend it to buy ice cubes from Paris. And ice cubes from Paris is $2 million, and they put it in their budget. And historically, every governmental entity around that has extra cash has played this game. And what happens is the Budget Commission has to take them for their word. Okay, they got this money planned to be paid for. And they approve the budget, and the tax gets collected. Well, in 2011 in Wood County, the Jobs and Family Services tax levy was suspended because they had too much excess cash beyond what they needed for their budget. In 1978, in Geauga County, one we all know near and dear, the Budget Commission did not certify a voter-approved health tax levy for collection. Because you see, the right of the people to vote is subject to not having more money than you need for operations, and it's the Budget Commission's job to make sure excess taxes aren't collected. I didn't invent this, folks. I got this message the night before the Budget Commission meeting on August 10th from one of the Budget Commission members. He came to me and said, Judge, because you don't have your old director, I bet you don't know this, but last year at the 2013 Budget Commission meeting, the county treasurer, Christopher Hitchcock, raised concerns about the Park District's 200% excess cash balance. They had 200% what their operating budget said they needed to operate for a year. And he warned the then director, now past director, that you better be addressing this by next year, and even 100% operating excess balance would be excessive. Now, folks, I listened to this recording. I went and got the recording. You can get it to the public records request from the Budget Commission. It's audio recorded. You can hear Mr. Hitchcock tell Mr. Curtin and Mr. Patterson, you got too much money, and you got to do something about it. Mr. Flays, our county prosecutor, said at this year's Budget Commission meeting that I went to on August 11th, that he felt they were misled last year by the Park District. And that indeed, the Park District has excess cash on hand. Mr. Mucci here, who's one of the board members, said at the meeting last week that the Park Board currently has enough cash to operate for 2 years without collecting another dime of tax money. And remember what the code says. Cannot levy a tax, even if approved by the voters, if the rate is clearly not required by the budget. And it's not, when you have 200%, you got a problem. So what happens? So we go to the Budget Commission meeting. There's 3 levies right now for parks in Geauga County. There's a .70 mil levy that goes back to 30 years, 20-some years. That raises about $880,000. There's 2 other levies. They each raise over $2 million. The question was not, was a levy going to be suspended? The question was, which levy was going to be suspended? The $880,000 one or a $2.1 million one? But because the budget that was proposed by the park had, the one that was actually given on that day, had a $9,200,000 excess cash in the bank for the Park District on December 31st of 2015. That means after spending $7 million in 2015. Remember that number. I'm going to come back to it. After spending $7 million to run our parks in 2015, at the end of the year, they were going to celebrate January 1st of 2016 with $9.2 million in the bank. Remember the excess cash concept, right? Remember Mr. Hitchcock from 2013 saying, don't come back and tell us this again. We went to that meeting and the Budget Commission was up in arms. You have too much money. You need to do something about it. Well, what are your, and by the way, with the tax levy that has now been suspended for next year, without that tax levy, and we kept that tax levy in place, we would have collected $6.3 million in taxes for the parks. Without that tax levy, we're still going to collect $5.4 million. So it's not like the taxpayers aren't going to pay a lot of money for parks next year. They're going to pay $5.4 million. And by the way, it's not like they're going to have no money left over. Had we left that levy in place, they would have had $9.2 million in excess cash minimum. By suspending the $880,000 tax levy for 1 year, next year, December 31st, 2015, the Park District will have $8.2 million of excess cash still in the bank. So it's not like they're going to be paupers, folks. They still have a lot of money on hand. Why do you have this process of the Budget Commission? Well, because voter-approved levies are subject to some variables. First of all, there can be misrepresentations during the campaign. There could be miscalculations that are unintentional during the campaign. There could be changes in circumstances. For example, the Park District, after being chastised last year by the Budget Commission, came up with a proposed budget that was going to burn off $1.9 million this year for such things as an 11% pay raise for some employees and a $700,000 increase in operating expenses. But the new Park Board, of which Mr. Mucci had a major part, was far more responsible in how they dealt with the spending, and they eliminated the 11% pay raises. They eliminated the new cars for park employees. And by the way, I love the park employees that are here, but I don't get a new car to drive to work in the morning from the taxpayers of the county. But there's a budget to give them new cars, and they can use them for personal use. No limits on personal use. I don't know about you. I don't ask you to pay for my car, and I sure as heck don't want to pay for a car for another government employee in this county. But that was in that budget that Mr. Mucci was able to put a hold to, and I'm sure he can explain a little better here in a couple of minutes. So the Budget Commission is the statutory balance. You folks are Tea Party people who are here. You understand what Thomas Jefferson said. We are a republic. We are not a mob democracy. We are not an anarchy. A republic is a place where certain people are in authority to make sure that law and order is maintained. And the Budget Commission's sole function is to make sure that people aren't overtaxed when it's not necessary to pay for the purpose of the tax or the operational costs. That's what proper government's about. Nobody violated any laws. Nobody violated the rights of the voters. The voter right, remember what I read to you, in the statute, 5705 3.1, is subject to this very Budget Commission process. And frankly, it worked. And I don't know about you, but when the Park Commission still has $8.2 million next Christmas, and that's Christmas 2015, not 14, I'm going to be glad that the taxpayers kept $880,000 in their pockets to pay for their children and their expenses and their bills. And by the way, if you're a senior, The senior levy's up this year. You know, there's some room for that senior levy if you're not hoarding cash for another purpose. And what would the letters say? I love the letters. There were letters that said that we were cutting programs and we're gutting the parks and the parks are going to fall down. Delusions, misrepresentations, and lies. Now, one naturalist programs got cut, correct, Mr. Butchie?
That's correct. They actually got expanded.
More naturalist programs have been added. We have brought some recreation to the parks, which I'll talk about in a minute. There was no land acquisition that was turned down or had been approved by a prior board that these guys canceled. I read that letter. Somehow the board canceled all the plans of the prior board. Absolutely not true. The only plan they canceled was the burning off of $1.9 million of tax dollars to play the Budget Commission shuffle. That was the only thing they touched. And they did it right, and they kept every program, every person who they needed for function, and they added programs to the Park District, and all those letters to the contrary are just flat out wrong. And there's been no loss of park services. I want to put the spending in perspective for a second. I said it before. The Park District is scheduled to spend over $7 million in 2015. The Department of Aging, which serves all of our seniors, a growing number of seniors in our county, is going to spend $3 million for next year. The Jobs and Family Services, for services for needy children in our county, is going to spend $3.5 million next year. The prosecutor's office, which is going to keep us safe and make sure guys are behind bars, is going to spend $1.5 million next year. And the Geauga County Probate and Juvenile Court, which is 2 different courts, a probation department, and 2 clerk's offices, is going to spend $2.2 million next year. What does that tell you? We spend twice as much on trees and raccoons than we do our seniors, our children,
Amen.
Law enforcement, and probate and juvenile services for all of our county. I'm not against the parks. I'm not against spending for the parks. We have a wonderful park district. We have invested over $100 million in Geauga County in our parks. And when it's needed, we should give it to them. When it's spent wisely, they should spend it. When there's land that properly should be acquired, they should acquire it. But they shouldn't be allowed to hoard money just for the heck of it. Because the Constitution doesn't permit it, the law doesn't permit it, and quite frankly, that money can be better spent. I guarantee you the seniors would like to see some more money for the senior programs. I guarantee you Jobs and Family Services, which is overrun because of the drug problem, would love to have some more assets so that they can help us take care of the children. I guarantee you Mr. Flays and I, who together spend half of what it's going to cost to run the parks next year, would love to have a few extra dollars to help fight the crimes, the drug epidemic that's causing crime in our counties. But that's what happened. And last but not least, let us talk about that famous list. The list of uses to be permitted in the park. The one that was so, frankly, beautifully, politically corrupted by those running for office, by those who don't like Tim Grendell, by those who want to continue their 20-year control of the parks at the expense of all the rest of us. They exploited this little thing. And you need to know the true facts. Several months ago, Montville Township introduced a passive zoning resolution. It was a resolution that rezoned just 2 properties in Montville Township. Interestingly enough, both of those properties were owned by the Geauga County Park District. One of them is Observatory Park. We got millions of dollars invested in Telescope in Observatory Park. A wonderful park. And with a lot of promise. But Montville decided that they wanted to tell Geauga County's residents, the 43,000 who pay taxes, how and when you could use your county taxpayers paid for parks in Montville Township. I thought that was crazy. The board thought that was crazy. We didn't think it was even doable legally. Oddly enough, there's a bit of a twist. For this board to maintain its superior position over the zoning folks in Montville Township, they have to have uses that they could then say were primary and superior to the zoning of the township. And the case on this is actually out of Geauga County. It's a case involving the Geauga County Park District and the bike trail and the zoning of the city of Chardon. And the Supreme Court, or Court of Appeals, and the Attorney General's office have addressed this. And the problem is it seems like you have to have more specific purpose in your county park bylaws to be able to combat local zoning control. So the board went and talked to their lawyers. They were legally advised you got to establish some uses to maintain control, and they came up with a list of approved uses. Unfortunately, that list got a little broad. And then suddenly there was oil and gas drilling, logging, and ATVs. And the letters started flying. And here comes the delusions, the lies, and the misrepresentation. They're going to clear-cut the parks. They're going to put oil wells in all the parks. ATVs are going to run over the horse people when they're riding their horses in the park. And all of that was untrue. What happened was there was a concern that the park district has already bought properties that have oil wells on them. And if you didn't have oil wells listed, that in the local zoning got you in the way, that you'd have to remove the wells and spend the money to remove and cap those wells. Should it have said only pre-existing wells in the parks? Absolutely. And unfortunately, because it didn't, some people had a field day. And some newspapers let them get away with it and misrepresent reality because it didn't quite spell out. Logging. Was anybody going to clear cut a Geauga County park? Not while I'm breathing. But here's the point. What if the ash borer comes and you got to blow out trees in the park to preserve the rest of the trees because of the ash borer? What if there's a fire and you have to do some cutting to protect away from the fire damage? Well, the park district wanted to be able to log for park management purposes. Should that language have said that? Absolutely. ATVs. Nobody's going to put ATVs in Westwoods where the horse people ride. That would be insane. They're good people. They should have their horse areas. We're going to protect their horse areas. They put a lot of time and money in those horse areas. They need to be protected. But is there someplace, an observatory park, which is 1,000 acres, or someplace else on the east end of the county where you can't put some ATV people to have some fun or some ski mobile people to have some fun? Absolutely. And the ATVs were in there because somebody thought you had to list ATVs for emergency purposes. That if you needed to get an ATV in here because somebody broke their leg, it would be prohibited by Montville Township zoning that allowed only passive use. The Montville Township zoning ordinance is still alive and kicking out there. It's not been passed. That ordinance would make the observatory that the taxpayers of this county have spent a bundle on a legally non-conforming use under the Montville Township zoning code. That's not right, folks. And that's what was going to happen. Unfortunately, the language was a little broad. Folks jumped all over it. I loved it. There was a letter from a gentleman, I think Mr. Webb. His letter went something like this. Grendell's got a plan to stop charging taxes for the parks, and we're going to put oil and gas wells and finance the operation of the parks solely off oil and gas wells. I don't know what he likes to drink, but I love a case myself. I mean, first of all, I'm not that smart. I don't have that time, and if any of you know me and have read anything, you know I was against oil and gas drilling. I've been against oil and gas drilling. I've been against oil and gas drilling in the state parks. I was one of the few Republicans who was against that, to my peril. I don't want oil and gas drilling in the Geauga County parks. I'm anti-fracking. That probably some of you disagree with me on this, but I've never been shy about my position about that. So it's just the language got a little loose. The political exploiters very cleverly did their number and did what they were going to do, and it was kind of, unfortunate. It's been fixed. The park board has addressed the issue with some language, what the lawyers tell me will be strong enough to beat back the passive zoning, and yet won't be exploited by everybody who thinks we're going to stop charging taxes for parks and do it by selling trees and oil, which is never going to happen. And so that's good. By the way, when I talk about passive zoning, we're standing in a park that is passively zoned by Russell Township. 4 townships have already passed passive zoning for parkland in this county, and the past board and director didn't even know it, or if they knew it, they did nothing about it. And that was just flat out wrong. And the park board's going to have to deal with it, and it's going to cost money to get lawyers to deal with it, because you cannot let a local township tell a park district of a county, financed on the backs of the taxpayers of that county, what they can do with their county taxpayer land. That's just not right. And it's going to have to be corrected in those townships that have already passed that kind of passive zoning. And somebody should have been awake, and if somebody allowed this to happen deliberately, somebody should have been fired. Now, last but not least, I got to touch this, the petitions. If one of you are going to the fair, if you're in a Democrat tent, they had the petitions on the table. If you're walking up the street in Burton, you were probably accosted by somebody who wanted you to sign a petition. And what the petition was ostensibly to tell the park district, we don't want logging, we don't want oil and gas, we don't want ATVs, and we want to go back to no recreational amenities in the parks. We don't want playgrounds for children. We don't want a volleyball court. We don't want horseshoe pits. And they had this petition. By the way, when I'm talking about that issue, I got to tell you, it's a marvelous thing. I get letters. I really thought that when you have 10,000 acres in the park, and only 3% of our park land is used for recreation, trails, parking lots, and roads. 3%. 97% of that 10,000 acres of parkland, approximately 10,000 acres, is preserved and conserved and not developed with anything made by man. So this idea that we don't have preserved and conservation areas in our park is preposterous and, again, delusional. Not a fact. There's space for limited recreation in our parks. For example, I suggested maybe you put a playground next to the pavilion between the bathroom and the barbecue pit so that when I'm here with my grandchildren doing this and my wife is over there setting the table, my grandkids aren't playing in the parking lot. They're playing on the playground, sitting over here. I got fricassee for that, folks. I'm a communist. I'm an anti-environmental socialist because I think there should be a playground right here. That's absurd, folks. So what happens is we put a playground, Orchard Hills. It's a lovely playground, apples and everything. Mr. Patterson should be happy. It's his theme. Okay? We put it there. Kids are climbing all over the thing. Look, Dad's cooking and Mom's doing her thing. And the kids aren't playing in the parking lot. They're getting lost in the woods. But what happens is I start getting the complaints. The people that Mr. Corsi called malcontents. I'll leave that as his phrase, not mine, but I can't tell you I'd argue with his use of the word. I'll call them complainants, give a little legal knowledge. The complainants do not want children in the parks. Why do I know this? The first time I suggested playgrounds in the parks, I get a letter from an older woman who says, Judge Grendell, I understand you want to put playgrounds in the parks. I said, yes. She goes, we don't want them. I said, why not? She said, people will bring their children to the parks. Wow, you think that's crazy? I got dozens of those phone calls and letters. I got the letter from the person who told me, I go to the park for solitude. I don't want to be disturbed by the laughing and playing of children in the parks when I go for my walk. Oh, help me, please. Okay? I mean, really? I mean, we spent $100 million so a handful of elitists can have their own private, place. There's a letter in the paper. I forgot which one of the papers wrote that published this goofy letter. Somebody who was a social worker or something said, I got an autistic child. And that autistic child needs to walk in the woods where it's quiet. We got 10,000 acres. I'll set aside some spot. I'll ask him to set aside some spot where autistic children can walk there. There won't be any noise. What does that have to do with a playground right here for kids to play? So that people can picnic and have their families together on a good old-fashioned Sunday afternoon picnic. It's preposterous. And my favorite one. If you've been to Froring Meadows, there's a soccer goal out there. Tim Grendell didn't ask to put a soccer goal in Froring Meadows. I think soccer's a communist sport, to be honest with you. Okay? I would ban soccer. And I'm going to lose all the soccer votes now. But I would ban soccer, okay? That's European football. But I get blamed for that thing. And how do I get blamed? I get a letter. The soccer goal will discourage the Virginia rail. Anybody want to guess what the Virginia rail is? Bird, all right? It's going to discourage the Virginia rail from flying to our park. I thought to myself, this was written to me by a gentleman who drives a big car, lots of shiny metal, into the park to go for a walk. And the Virginia rail is so discerning that the reflection from the metal of the car does not disturb it. But the reflection from a much smaller soccer goal that has a white netting on it will disturb that bird. That is one great discerning bird if they can tell the difference between cars and soccer goals. Cross-country skiing. We don't have a cross-country skiing chalet in Geauga County. Chapin Woods and Lake County does. You can rent cross-country skis and ski. Golf course. Here's communism. You can't have a golf course in the Geauga County Park District, even though there's 8 of them in the Cuyahoga County Park District, 2 of them in the Lake County Park District. You can't have snowmobiling, even though they allow snowmobiling in Yellowstone, and if you're an environmentalist, there's nothing greater on your list than Yellowstone. But yes, they have to be 4-cycle engines so they don't make a lot of noise. They have to be during the daytime, and you have to get a permit so we make sure you know what you're doing. Can be done. How about the controlled hunting? I love this one. There is shooting on that magic list because since 2006, the Geauga County Park District has allowed controlled hunting. I became judge 2011. How come for 5 years Judge Henry wasn't getting the angry letters from the environmentalists saying, you're going to allow shooting in the parks. People are going to be getting carried off in baskets in the parks. This park district has allowed controlled hunting since 2006 without any injury or incident. Nobody was going to bring the Western Corral out here to start shooting hikers walking through the parks, folks. And the letters that said that were delusional, misrepresentative, defrauding, and outright lies, folks. All of them. And we have enough parkland for everybody. You know, you can have horse places that only horse people go. You can have a cross-country ski place that only cross-country ski people go. You can have places for people to have solitude. You can have people for people who have kids. You can have people who want to play horseshoes, and you can have people who don't want to play anything when you got 10,000 acres, folks. But there's a small group of malcontents, Mr. Corsi's term, who for years had it their way and only their way, had a board and a director who did only what they wanted, and they can't stand the fact that times are changing. Newspapers are allowing them to write anything because it's under the guise of the First Amendment, so be it. But it's not true. And it's just a disservice to the people of this county. And if you want to see something really interesting, well, let me go back to the petitions and then I'll finish with the letter. Remember those nasty little petitions? 2,500 signatures. Well, 932 of those signatures are not from Geauga County. And I tell you what, I know that as a fact because I counted each and every one. I have a set of the petitions. If you want me to verify it to you, I will do it under oath. 932 people. They came from New York. I don't know about you, but I don't like what New Yorkers do in New York, let alone tell me what to do in Geauga County. They came from Pennsylvania. They came from President Obama's state, Illinois. The majority came from Cuyahoga County and Lake County. Is anybody here who's surprised that people in Cuyahoga County want to tell us in Geauga County what to do in our parks? I'm not surprised by that. Of course, how much tax money have those people paid for Geauga County parks? A big flat zero. But they want to tell us how they use our parks. We have firsthand reports from people who were walking to the fair, who were confronted by some of these signature solicitors, who flat out lied to them. Showed them a picture of a clear-cut forest and said, this is happening in Geauga County parks today. Not true. Told them that Geauga County was going to bring invasive species to the parks. Not true. I'm not even sure what an invasive species in the park is, except maybe judges coming out to talk at night. To those people, I guarantee you, tonight I'm an invasive species. I guarantee you that. They had all sorts of misrepresentations that they made to get people to sign those signatures because they have an agenda that wasn't dealing with the truth. But I left you something on this page, and if you haven't followed my outline and you want to know all these sites and you want to see the facts and the statutes that underlie everything I said tonight, it's right here in this outline. But the last page of the outline really tells you where you stand on this issue. The front is a letter from a lady from South Euclid. I am against any serious changes to the natural scape of the Geauga County parks. Thank you, ma'am, for your tax dollars and your opinion. They are beautiful in and of themselves. Absolutely. Do not need fracking sites. Absolutely. ATV trails. Most of them. Absolutely. Maybe someplace there's one place we can do it. Or any other unnatural effects, i.e. playgrounds. Absolutely not. There is plenty of recreation in them for citizens to enjoy without altering them. Thank you, ma'am, for your opinion. There are many altered places for people to go without developing these parks into a natural settings, like the parks in South Euclid, where I grew up, by the way. I guess I should go there if I want to take my grandchildren to a playground. I do not live in Geauga, but go there to these parks a great deal. Well, that's fantastic. We're glad that you're a neighbor, but how much did you pay for that privilege? Oh, she had a horse here at one point, but I don't think she does anymore if you read the letter. She makes a personal attack on John Kasich, and then sort of ends up by basically saying that there's some sort of mismanagement. And this is the group who have spread the delusions, the misrepresentations, the lies. But they're also entitled to their opinion. And if this is what you believe, join the chorus and write another letter to the Park District, because here's your model. But let me read to you the other letter, the backside, from two people, Charles and Sharon Osborne, who live in Middlefield, Ohio. For those from the media, and for those of you who are going to write ugly letters about me, Middlefield is located in Geauga County. South Euclid is located in Cuyahoga County. Let's at least get those facts straight. But here we go. Greetings, Your Honor. I am taking this opportunity to commend and thank you for the professional and equitable manner in which you have discharged your duty in appointing members to the Geauga County Park District Board, who as a body truly represent all the citizens of the county. For far too long, previous boards were dominated by members representing an activist minority, espousing only one elitist preservation position and suggesting that this should be the sole mission of the board. But activism by a minority must not shape policy different from the will of a majority. That majority, and I also support passive natural type activity, but not to the exclusion of recreation. With many thousands of acres under board control, there are plenty of lands available for both types of activity to occur concurrently and separately without conflict. Your wise and fair appointments have assured that Geauga County now has a park board which will guide the district in direction for which will serve the interests of all Geauga County residents. If you believe this, you need to write letters to the editor so people in this county understand that there are fair-minded, fact-finding, truth-seeking people who understand the truth here to dispel the delusions, the misrepresentations, and the lies.
And if I may add, Judge, come to our next board meeting on October 14th, right here at the Westwoods at 7:30.
Be here and let them know there's other people in this county. When all is said and done, the Geauga Park District will continue to operate in a manner that preserves and conserves the county's valuable natural resources while providing appropriate recreational opportunities with sufficient funds to accomplish all of these purposes for all Geauga County residents and not just for a select elite few. Folks, that's my philosophy of the park. Right there.
Judge,
and you know what? Under the code, I can do that.
Now, you're going to open up the question, and this little fellow's going to answer your question just the way, he just said it the way it is, right now.
Question.
It sounds to me, Judge, that even after all the spending that's over next year, the Park District is still going to have a slush fund of about $8 million. Is there any way that you can get it out of there?
Well,
give it to the departments that really need it?
You cannot recycle the money. All they can do is to find ways, budget for it in the budget if it's needed, or continue to seek a suspension of collection of some of the taxes and burn that off. Remember I told you you're going to collect, without doing the $880,000 tax that you guys are not going to pay next year. The tax revenues will come in around 5,152. Your spending is going to be about 7, so you're going to burn off 1.8 from that money, roughly. But what will happen is over a couple of years, you'll be able to suspend the tax levy and burn off your excess until you become back in equilibrium.
So it's got to be burned off.
Right. Now, they also could acquire some land, and I mean, there are some people who believe we have too much land in the Park District. There's some that think we don't have enough. And my philosophy is simply this. If the right land becomes available at the right price, then the county needs to acquire the land because you only get that opportunity once. But to just go burn the money off for land that doesn't serve a specific purpose, in my opinion, would be imprudent and wrong.
Thank you.
Yeah. Related to that question, is it possible to revise the levy to adjust it, take it back to the citizens of the county to right-size it to the park?
Oddly enough, that's Mr. Claypool's question. Oddly enough, yeah, there seems to be some case law that gives authority to the Budget Commission to modify, but it seems to apply to only inside millage, which is millage the Park District can put on. Does not seem to have that language about the electorate. The electorate language seems to only be suspension, but I got a feeling they probably could do some sort of modification. So you know, in 2019, one of those levies comes up. One of those 1 mil levies is ending in 2019. That's about a $2 million once drop in revenues. That's an issue that Mr. Mucci and the Park Board over the next couple of years is going to have to address, how they seek that situation. The $880,000 levy that's been suspended runs to like the year 2000 and I think 24, 26. It runs for a long time yet. So if they kick that one back in, it'll cover some of the loss of the 19 levy and they'll have to adjust to figure out what they're going to do for revenues come 2019.
Yeah, can I jump in for a second, Judge? Just to kind of clarify a little bit there. The reason why the Budget Commission can address the inside millage is because that's millage that townships and municipalities can levy without a public vote. Okay? The park board's levies are all outside that 10 mil inside millage amount. So that all has to be voted on by the public. The second thing is you can't take your budget to zero at the end of the year. And the reason is that we don't get the first half's tax collection until generally March sometime. So we have to have enough of a carryover balance to account for that. But if you do it right, it all kind of, once you get the cycle going, it all kind of flows through.
And just to put that, the carryover for the Park District, according to the Park District witness at the Budget Commission, is $1.4 million to operate for the first 3 months of the year. That's still not $8 million, so it's $1.4 million.
Right. There's still plenty of available funds for purchases and whatever else we may need.
Like generators?
Yeah. And a toilet system that works.
I'm actually pretty surprised they don't have one in there.
Judge, you mentioned 10,000 acres currently in our park district. How many acres are in the county, and how does our acreage compare to other counties in the state of Ohio?
I don't know how many acres in the county. My point of reference is Lake County has 2.5 times the population of Jogger County and has about 12 to 1,500 less acres of park than we do, and that includes their 2 golf courses. We have no golf courses. So by population to park acreage standards, we're up there as a county, and that's a good thing. I'm not adverse to that. That's a good thing. And I'm not adverse, like I said, with the right properties under the right circumstances to acquire. There are some properties in this county. For example, if you ever drive down Mayfield Road, goes out by that hill and that old wetlands area and all that over there, that's the habitat for the natural brook trout. There's no way you or I are ever going to walk on that property. And nor should we, because we shouldn't be disturbing the unique nature of that property for the preservation values that it has. There's a substantial amount of acreage in this county owned by the Park District that is not open to the public. So there's how many that is? Do you know?
I don't know how many that is, but in addition to the Park District, you've got the City of Akron owns in Burton Township, Troy Township, and Clarendon roughly a third of all the land there. You have Nature Conservancy, Natural History Museum. They all own significant chunks of property here as well.
I think 3 to 5% of Jogger County is in preserve, conserve green space. When you add the Park District, the Akron watershed, and other park land, I think we're something like 3 to 5, but I don't know what the total acreage of the county is.
Isn't it true that all those lands that Akron buys are off the tax duplicate?
Yes.
Well, so are the county parks. I mean,
right.
Public land is not taxed, so that 3 to 5% is off the tax.
As a former Burton Township trustee, I can absolutely verify that the Akron-owned land, with very few exceptions, is off the tax rolls.
Anybody else? Yeah.
Judge, I got a question. I'm just wondering about some of those irrational malcontents that are complaining. What would be the possibility of some of us getting the forms to file probate proceedings against them?
I'd have to disqualify myself. I would feel that I couldn't in good conscience say that I would be unbiased if somebody did that. Look, First Amendment, you got all the rights in the world. I just wish you wouldn't mislead the rest of the people in the county. And the problem is, and the newspapers know better. I mean, I'm not going to say which papers, but we have sent some of this information to some of the newspapers who then go around and in their articles, they're wrong. There is one newspaper writer, I won't call him the reporter because reporters have journalistic integrity, and in Tim Grendell's opinion, he does not. But that person will just about write anything any of these malcontents tell him as if it was the truth, even when he knows it's not, and hide behind the the case with the New York Times where I'm a public figure, so you can say anything you want about me, and there's not a whole lot I can do about it because the Supreme Court says tough luck. That's what happens when you get into government. And that's fine, I got it.
Yeah,
but it's not me I'm worried about. It's the people out there who read that inaccurate information that are getting misled.
But we're your supporters. Couldn't we file those forms?
That's up to you. I won't say.
Well, and one other thing to keep in mind, the First Amendment's a wonderful thing. And it gives everybody the ability to string hearsay, innuendo, and conspiracy theories till whatever fantasy they want to spin. However, it does not require that anybody has to listen to them. So I would encourage you to let people know that just because somebody is blabbling at the mouth doesn't necessarily mean it's worth listening and paying attention to.
Except for the judge. Yeah.
I would just like to know if you have any numbers, any figures on the number of people or the percentage of people in Geauga County who actually use the parks.
I wish we had Mr. Rose here today. I believe that they have some statistical stuff. There's going to be a survey coming out. You're going to get your chance on this. A little later this year or the beginning of next year, the Park District is going to send out a survey asking for the people's view of what our park should do and what services we should have. Do we need more recreation? Do we need less recreation? You're going to get your chance to weigh in. I hope you will fill out that survey and send it back to the Park District, but you're going to have to ask the folks at the Park District. They have those numbers. I just don't have them.
Yeah, we track the number of visitors that come to programs, where there's someone who's conducting an event. But we, at this point, do not track who just shows up and walks the trails or uses the pavilions or things along those lines.
There is one funny anecdote, though. When this group of, of course, these malcontents got together for the first time at throwing medals to complain about the soccer goal, there was a father and his two daughters practicing soccer at the soccer goal. I don't think they felt that it was wrong for them to be able to practice soccer there. This is a big county, folks. 10,000 acres. There's room for everyone. That young lady there, yeah.
I appreciate your comment. Some of the things I do disagree with only because I was here since 1976 as an employee. And I'm going to speak mostly about, I'm Sherry Bosworth. And I served for all of the directors, back to Judge Ford, Judge Moon. This park that you're sitting in, the Park District did not have the money when it came time to purchase this. This is going to be taken over by a developer. But ASM employees and ASM themselves said, we would rather it be a park. What can you do? And that's when Bill Ginn stepped up, gave the money to the Park District, and then we had to go into an arrangement to pay him back based on then passing the levy. So the reason the Park District, and I don't like the word hoarding, I hate that word, the reason the Park District prepares themselves for that money ahead of time is because if land came up. Burton Wetlands, the same thing. We did not have the money at the time. The Nature Conservancy held that until the Park District could raise the money to purchase it on. So the reason money is set aside is for land acquisition. To pave 1 mile of road, I believe the figure is $1 million. So those things have to be prepared for. When you compare budgets with the probate court Department of Aging, are you comparing a staff of 60? Are you comparing that the Geauga Park District is encompassing a park? Is the previous board's vision was to have a park district within 10 minutes of every resident of the county. So your money that you were paying would be there and you would have access for it. The original park board, the original League of Women Voters, they wanted the land to be preservation. That's mostly what it was all about. That's why if something comes up that you don't know, there's an estate, maybe someone passes away, they want their land to go to the park district, but of course they want it to be paid for. They don't want it, people can't just give away their land anymore.
If I could add a few things, this park was purchased in part by my wife. This park This park was purchased in part by my wife, who was in the State House and got money from the state legislature to help purchase this park. So let us not skew the story in one way again. Let's get the true facts on the table and not half the facts. Second, the Park District has $3 million set aside for property acquisition for 2015. This isn't Tim Grendell's numbers. This is the excerpt from the budget hearing worksheet prepared by Michelle Pinnell, representing the Geauga County Park District. And the statute, despite all intentions, does not allow the hoarding of funds for park acquisition land. It's not in the statute. If they want to fix the statute, talk to Mr. Eklund or Mr. Lynch. It's not in the statute. I got the extra money to buy Orchard Hills from the Patterson when I was in the state senate. So we kind of need to leave things in total perspective. Yes.
And some of our members in the Ohio Horsemen's Council went from door to door and raised funds to help pay for this park.
I agree with that. The Horseman Council have been major players in the acquisition and the maintenance of this park. And that's an absolute truth.
Well, and one thing, I do want to add, we are very, very blessed here in Geauga County with the public-private partnership that goes on with the Park District, the Geauga Park District Foundation, groups like the Ohio Horsemen's Council, and just other individuals who have donated money and or land to the district. So that's something that makes us the envy of a lot of the different park districts around the state of Ohio. And that's not something that we want to tamper with or endanger at all. I mean, Sherry is correct, and both Judge Grendell is correct. There's a balance there between having enough funds to be able to take advantage of an opportunity when it does come available, but you also have to balance how much is that relative to your total budget and what you expect any potential future purchase might be. And I would argue that we clearly have too much in that pile waiting in reserve. We can afford to give some of that money back to the taxpayers by not collecting it, and we still have the ability to make purchases, if and when they do become available. So we are actually in a sweet spot. Let's not beat ourselves up for being in the position we're in. We can save money for the taxpayers, and we can still have money available for strategic purchases when we need them.
And anybody who feels they were slighted by not having to pay that extra $880,000 in taxes next year can donate that money to the Park District, and the Park District will gladly collect that from you. Thank you all very much for the time.
Thank you.